The Rules Committee will come to order. We are here for consideration of a resolution that provides for motions to suspend the rules, including a balanced budget amendment to the Constitution, and the chair will be in receipt of a motion. Excuse me? Oh, I didn't know we had testimony. I guess we have testimony here. For some reason, I thought we were going straight to this, so I thought we were... Mr. Nadler, thank you very much for being here. As I said, this resolution simply provides for consideration of the measure on the floor under suspension of the rules, but we're happy to have you, and enjoyed seeing you here yesterday, and so you obviously are a glutton for punishment. I think it said Mr. Goodlad is coming here as well, but since he's not here, we'll begin with Mr. Nadler, and just as you did yesterday, we'll say once again that that beautifully printed statement will, without objection, appear in the record in its entirety, and we welcome your summary.
Thank you, Mr. Chairman. Although I am fully aware that these decisions have not been made in this committee, I'm nonetheless here to urge the committee not to proceed with consideration of a balanced budget amendment to the Constitution. Put simply, the House is proceeding recklessly with a question of tremendous gravity. Our Constitution, the nation, and future generations deserve better. The legislation being considered by the Rules Committee today was never considered by the Judiciary Committee, was never the subject of debate, markup, or amendment, and was not seen by any member of this House, or at least by most of us, until just a few days ago when it was posted on the committee's website. Needless to say, this is not how the people who wrote our Constitution handled their important task. It is not the way past constitutional amendments have been considered, even during the heady and reckless days of the Republican contract on America, was it 17 years ago. I understand that the committee intends to make no amendments and no alternatives in order. That would be an outrage and an affront to our democracy and our Constitution. Is this the meaning of constitutional conservatism? It is neither respectful of our Constitution nor is it conservative in any generally understood meaning of the word. In a recent hearing, the majority called 3 witnesses to discuss the balanced budget amendment in general terms. Although minority members sought to get the views on different provisions or proposals of the majority witnesses, all the witnesses declined to offer a viewpoint because they were not familiar with the specific proposals, but had only been invited to speak generally. The version before you today was not available at the time, although according to the timestamp it appears to have been written a few days earlier. We are not, however, considering a general principle. We are considering actual language that is proposed to be added to the United States Constitution. We and future generations will have to live with the consequences of that amendment, the actual language, not general principles, and its actual meaning. To so recklessly put before the House a proposal that is radically different from the one debated by the Judiciary Committee, and is different in important ways from the one we considered back in 1995, and to consider it without allowing any alternatives is a dereliction of our constitutional duty. I realize that the majority has had a difficult time holding its members together, and that consideration of a balanced budget amendment was part of the deal for securing votes in the Republican caucus on the debt ceiling. But that is no reason for this assault on our Constitution or for skipping vetting the amendment, the actual text of the amendment in the Judiciary Committee. It is this sort of stunt that has brought this institution into disrepute. If we can't even handle amending the Constitution seriously, then we really have failed the nation. I urge the committee, regardless of the political needs of anyone, to send this proposal back to the Judiciary Committee for serious and proper consideration. Actually, you'd be sending it to the committee for the first time, since it has not yet been introduced in that committee. If this committee is determined to move forward with this assault on the Constitution, I urge you to allow members to propose alternatives so that the House can at least debate the specifics of different approaches. For example, should Social Security and Medicare be protected? One supporter of this amendment insists they already are. That is news to the Republican members of the Judiciary Committee who debated this very question and insisted that amendments specifically doing so would nullify the impact of the amendment. So is the member correct in stating that Social Security and Medicare are protected and the amendment has, in the view of our Republican members, a hole big enough to drive a truck through, or is he not correct? We should at least have the opportunity to debate the question and consider alternatives. What kind of remedy may federal judges order to enforce this amendment? Or is it unenforceable and therefore a dead letter? Would federal judges be able to order tax increases in order to obviate an imbalanced budget? Would they be able to order cuts in military spending? How much difference should federal judges give the estimates the amendment allows? Should they substitute their own judgment, or can we cook the books in any way we want? We don't know. Shouldn't we make some effort to figure out these implications of this amendment? This is an important debate, but it is being treated as flippantly as if we were declaring National Mom and Apple Pie Week. We should not do that. The framers would never have given us the power to amend the Constitution if they had foreseen this charade. It is not too late to act responsibly. I urge you, at the worst, to allow alternatives, but really to do what you should do and refer this bill, this proposed constitutional amendment, to the Judiciary Committee for, the statement says appropriate consideration, I'd say consideration, since it has not been before the Judiciary Committee, or for that matter, any other committee of this House until now.
Thank you very much, Mr. Nadler. You offer a very interesting perspective on the role of this committee and on the process here. Let me explain. All we're doing is expanding to 5 hours. 5 hours, the floor debate on this measure, and it is going to be considered under suspension of the rules. And the authority that will exist for that will allow for free-flowing debate. There are 242 bipartisan co-sponsors of this measure, and I think that for us to have an opportunity for this kind of debate time is, I think, going to allow us to do it. So I mean, I appreciate your perspective. I don't agree with it, but I have no questions. Mr. Sessions. I have no questions. Thank you. Mr. McGovern.
Yes, Mr. Chairman. And while I guess we appreciate the additional time, the fact of the matter is if you bring a bill to the floor under suspension of the rules, you don't even have a motion to recommit. So not only will you have no amendments, but you'll even be denied that. And again, I find this all very curious. I guess people can give speeches and issue press releases, but you're not going to be able to legislate on this bill. I just want a couple of questions. It's my understanding that the House Republican Conference rules prohibit bringing bills up under suspension if they're not cleared by the minority. And I guess you're on the committee. Was H.J. Res 2 cleared by the minority?
Not to my knowledge. The committee. It was not submitted to the committee. The committee held no markup, no hearing. Well, we held a hearing on the general concept of balanced budget amendments, but not on this bill. And as far as I know, it was not. Certainly not okayed by the minority.
The House Republican Conference rules prohibit bringing bills up under suspension if they're opposed by more than 1/3 of the members of the committee of jurisdiction. Do you know, was H.J. Res 2 supported by 2/3 of the members of the judiciary?
Certainly not.
Just for the record, I mean, let me ask you, was there even a vote on this bill in the Judiciary Committee?
There was no vote on this bill in the Judiciary Committee.
Yeah, just for the record, I mean, the House Republican Conference rules, Rule 28 clearly states that, quote, Republican leaders shall not schedule or request to have scheduled any bill or resolution for consideration under suspension of the rule which has not been cleared by the minority or was opposed by more than 1/3 of the committee members supporting the bill. So I point out, the other thing is, in this bill that we have before us that was not voted on by the Judiciary Committee.
Or even marked up.
Or even marked up by the Judiciary Committee, that's just here and it's being brought up in the suspension of the rules with not even an opportunity for motion to recommit. My understanding is that Section 5 allows Congress to waive the provision of the Balanced Budget Act for any fiscal year in which a declaration of war is in effect. It allows Congress to waive the Balanced Budget Amendment, quote, for any fiscal year in which the United States is engaged in military conflict which causes an imminent or serious military threat to national security and is so declared by a joint resolution adopted by a majority of the whole number of each house, which becomes law. I raise that issue because we've been at war in Afghanistan for 10 years now. And I think we've been at this long enough to have a pretty good idea of how much it's going to cost year to year. And yet we have chosen not to pay for that war. We borrowed $10 billion a month for that war. We didn't pay for the Iraq war. And we're now in this habit of going to war without any consequence, when nobody pays for it. We put it on a credit card. And when you look at how we went from surplus to deficit, these wars and our lack of willingness to pay for them is a big contributor to that debt. And so we're now in this, we have a super committee talking about cutting Social Security, cutting Medicare, cutting money for environmental protection, cutting money for education, medical research, and nobody's talking about the war. And so what this balanced budget amendment would essentially do is allow the status quo to go forward. We don't count war spending, we just keep on going. There's no offsets, there's nobody who has to be taxed for it, it just happens. Is that your understanding of this?
It is my understanding, as long as there's a war declared or an authorization for use of military force, as is the case now, it would be waived during that time period, at least to the extent of the total amount of expenditures on the war.
Well, I think Democratic and Republican presidents alike have ignored paying for the war, and Democratic and Republican Congresses alike have ignored paying for the war, and now we are in this deep hole. And I would just, again, say that I think this is a loophole that is, I mean, when you add up the war costs, I mean, the amount that we've spent in both these wars that has not been paid for, it's, to me, out of control. Anyway, but I thank you for verifying that the Republicans kind of dismissed their Congress rules. Yes,
A couple comments. The point of bringing a bill up on suspension is you need a two-thirds vote.
right.
You need a two-thirds vote for a constitutional amendment anyway. Therefore, the only goal of bringing a bill up on suspension is to deny the minority the motion to recommit. That is the sole reason for bringing a bill up on suspension, to deny the motion to recommit. As you point out, it violates the Republican conference rules, but if they want to violate their rules, no one can stop them. Well, second point I want to make, you bring up a very good point about the exception here for a period of wartime, and the fact is we've been in a period of wartime for the last 10 years, and maybe for who knows how many years, and it nullifies the whole thing. But the other thing is, there's nothing in this proposal that tells us how it would be enforced. And I alluded to that. If it says Congress shall not pass a bill, the President shall not propose, and Congress shall not pass a budget in which outlays exceed income. What happens if it does? Or what happens if the estimates are wrong? Could a federal judge under this decide we're going to cut the military budget, or we're going to cut education aid in half, or we're going to order a rise in income taxes? We don't know. It's an extraordinarily vague proposal that says you may not do this, but if you do it, what happens? Are you giving a power and equity to a judge to order a tax increase or to order an expenditure cut? Unknown. Well, and if you're not, how else would you enforce the amendment?
Well, those are interesting questions, and I know Mr. Goodlatte just arrived, and maybe he can explain why the Republican conference rules have been disregarded in the way this legislation has been handled, but I'd yield back my time.
Let me just say that we got a questioning of the witnesses. If you'd like to offer some comments without objection, your statement will appear in the record. And Mr. Sessions, Mr. Governor, I've already gone through the questioning portion.
Well, thank you, Mr. Chairman. I apologize for being late, and I will submit my statement for the record. This is, as the committee is well aware, the balanced budget amendment that was taken up in 1995, passed the House with 300 bipartisan votes. There are a couple of tweaks, and I take it that the gentleman from New York was referencing one of those related to military conflict. I think that that clearly tightens up the language so that a majority vote would not by itself open up the budget to be not balanced for any purpose. It would tighten it so that it would only be out of balance to the extent of the cost of the military conflict. As to the comment that I just heard regarding the enforcement issues, as with the entire Constitution and other amendments that have been passed, this is very much the way our Constitution is written, and it is resolved by the various powers between the executive branch, the legislative branch, and the judicial branch. And there's an excellent piece on this that was written by the Judiciary Committee staff when this legislation was considered in 1995, which if there's no objection, I would submit for the record to the committee. I thank you, Mr. Chairman, and I would just say that the real enforcement mechanism of our Constitution is a balance of those various powers, but primarily rests with the people. And if you don't balance the budget, you're going to be held accountable by the people through the polls. But you don't want to have, in my opinion, a constitutional amendment, a provision in the Constitution that outlines in the minutest details who would have standing, what the remedies would be for the courts, and so on. By the same token, you don't want to take all of that off the table either, because that's the natural tension that exists that has worked well for our country for the entire 200 years, that we have remedies through this process, but those remedies are not in our Constitution spelled out in the kind of detail that apparently the gentleman from New York is calling for.
Thank you. And as I prepare to call on Ms. Fox, let me just express appreciation to you for your dogged pursuit of this issue. I know it's been a very high priority for you, and you've been working long and hard on it. Ms. Fox.
Thank you, Mr. Chairman. I'd also like to thank Mr. Goodlatte for his good work on this effort. He and I have had many discussions on this legislation, and I appreciate not only his good work, but his very positive attitude and as you say, his dogged determination to gather votes for this amendment. And I have no questions. Thank you.
Mr. Chairman, on Thursday night, this new substitute, H.J. Res 2, appeared on the website.
Last Thursday?
Yeah, appeared on the website. And it doesn't say whose amendment it is. And I'm just curious, who wrote this mystery text?
Well, I don't know that it's mystery text. As Mr. Goodlatte has said, that this is a measure with a couple of tweaks to it that passed in 1995. So I suspect, am I fair to say this is yours?
Well, it is the H.J. Res 2 I introduced at the beginning of this Congress. The tweaks have been made with the support of the Judiciary Committee and the chairman, on whose behalf I am here today.
Well, did they have a vote in the Judiciary Committee? Did they have a vote in the Judiciary Committee?
No, not this time. They did.
Well, how do you say then, Mr. Goodlatte, that it has the support of the Judiciary Committee?
Well, it has the support of the Judiciary Committee chairman and staff that prepared the
Fair enough.
language.
I know if the gentleman yielded, I don't know if the
course.
gentleman was here when I said that there are 242 co-sponsors of the measure. So I think that
But then there were measures, the measure itself was changed. You're saying that it was tweaked in some way, and I'm just asking who approved it?
Well, I think that the measure that was introduced last Thursday has these couple of modifications that Mr. Goodlatte was referring to, and it was introduced, and I assume are the 242 co-sponsors on this measure that was introduced last week?
No, the co-sponsors are on the original measure as introduced.
I see, okay.
Well,
So,
just to make a statement, I certainly appreciate Mr. Goodlatte's work on this and Mr. Nadler's, and it's not something that's new. First, I predict for you that if it gets two-thirds votes or votes in the Senate, it's not going to pass. In the House, it's not going to pass the United States Senate, and if it did, the President would veto it. And I think we all know that. So you begin to wonder sometimes why we sit around and do things that are going nowhere fast. And the unintended consequences for this kind of action are perhaps not clearly understood by most of us. I'm just curious, does anybody know if by chance it were to pass, the Senate and the President signed it, does anybody have an estimate as to how long it would take before two-thirds of the states would confirm?
Gentleman yield?
Sure.
I thank my friend for that, and I just remind my friend, and I know that being the judicial scholar that he is that the President has nothing to do with this whatsoever. This is simply sent to the states. And
Right.
So it would take the two-thirds passage of both houses of Congress, and then
Appreciate-
three-fourths of the states.
appreciate
have it.
that.
So the president will.
Do you have any estimate as to how long that would take?
Well, I know the
Thank
average.
you for correcting.
I think the average amount of time for the ratification of constitutional amendments has been 7 years, if I recall.
That's
what I recall in the past, that's what it's taken.
All except
That's a maximum.
D.C. voting rights.
It's also the average.
Yeah, well, that probably raises the average.
Yeah,
That
right.
plays a role in raising the average.
I'm pretty sure it does. And thank you.
for yielding.
I do not attest to all of the judicial scholarliness in the world, but I did serve 13 years.
I didn't say you got all of it, but a lot of it.
Yeah, well, to the extent that I have it, I can tell you this much. I don't know any federal judges that are in a position to determine and decide whether weapon systems or social security should be cut off and how much. And I think that this measure opens up. I understand Mr. Goodlatte's point about the separation of powers, but different than other measures in the United States Constitution. If this were to be in the United States Constitution, I think what it would do is it would open up a way for thousands of lawsuits, and my friends on both sides of the aisle have been very critical of the litigiousness of American society, and probably with good currency. But the fact remains that it would be a lot of litigation. Let me yield.
Yeah,
Mr.
I thank the gentleman for yielding. And again, Mr. Goodlatte, you weren't here when I asked these questions to Mr. Nadler, but I'm curious, why wasn't there a vote in the Judiciary Committee? And I also, I raised the issue that the House Republican Conference rules prohibit bringing bills up under suspension if they're not cleared by the minority. Mr. Nadler tells me that H.J. Res 2, as written, was not cleared by the minority. The House Republican Conference rules prohibit bringing bills up under suspension if they're opposed by more than one-third of the members of the Committee on Judiciary. And we're told that standard wasn't met either. You have the time. We have the time. It's not like this has to be done right away. Why not go through regular order, and why kind of violate your own conference rules to do this?
Well, if I may,
Yeah.
the balanced budget amendment that was passed out of the committee after much debate earlier is a H.J. Res 1, a different version than this version, and the changes that were made because there is a tremendous amount of interest on your side of the aisle. I understand that there are members, including the gentleman from New York and others, who do not support either version of the balanced budget amendment, but there are many members who support it. So
why not regular order?
The change, well, because of the fact that this is something that requires a two-thirds vote to begin with. So the decision is not mine, but the process is one that I think is very fair. It's been done to try to accommodate and find common ground for as many members of Congress as possible, and then bring it up, and instead of just
You're violating your own conference rules, and you're bypassing the Judiciary Committee. I'm just trying to. It's not like this is an urgent thing that had to be brought up today. Why not go through regular order? I mean, and again, allow members to be able to have if not an open process, a semi-open process under suspension. We're not even allowed a motion to recommit, and I don't care if everybody but one person doesn't supports this bill. Fact of the matter is, I just kind of think when you were in the minority, my friends on the Republican side made a big deal about regular order. I just don't quite understand why that's such a big lift in this instance.
Well, I can't speak for the committee. I can't speak for the chairman. I can't speak for others who are involved in the decision-making process. All I can say is that I think the process has been very fair and has been done in such a way as to try to open up this process and to offer to the Congress a vote on a bill that has already passed the Congress once before. It's not novel. It's not new to the.
I would suggest that maybe you might want to offer an amendment to your Republican conference rules to change them, because you're violating them very clearly here.
I can't speak to that.
You're back.
Thank you
Well,
very
gentlemen,
much. Of course,
Since all this talk has gone on about the decision-making process, I will tell you that I was involved in it, and I'll just enlighten my friend if I might. As I said, there are 242 bipartisan co-sponsors of this balanced budget amendment, And it's no secret that there was talk about another approach to deal with this. And there was an overwhelming response from the majority membership, which was reflected in a leadership decision to proceed as we are proceeding. And there are no rules being violated, no conference rules being violated. And I will just say that, again, as Mr. Goodlatte has correctly said, the requirement of a two-thirds vote is what takes place under a measure that is utilized under the suspension of the rules. Well, actually, Mr. Hastings has yielded to me. It's up to him to decide whether he wants to yield to you or not.
Are you finished, Mr. Chairman?
I'm all finished.
And I'll yield back to Mr. McGovern at this time.
And I just, for the record, I mean, I'd like to ask unanimous consent that we put some of the Republican conference rules on suspension in the record, because it's very clear that you have violated those conference rules. Now,
Will the gentleman yield when he's done? When he's done.
When he's done, sure.
I ask
I'll
unanimous
yield.
consent to put them in the...
Without objection, and then I'll ask unanimous consent if the gentleman yield to me to include a copy of the record, in the record of the rules, which, let's see what this is. This is Rule 28, subsection B, which says a waiver of this rule can be granted by the majority elected leadership as defined under Rule 2. I thank my friend for yielding.
Mr. Chairman.
I thank my friend for yielding.
Last week, the House Republicans held a series of listening sessions that culminated in a specific conference meeting and a member survey where lawmakers debated which version of the BBA to bring to the floor. What's curious is that you're willing to discuss within your own party this measure, but not willing to hold a single hearing or allowing amendments, debate, or a motion to commit. And while it may be that you have the power to do what you did, the question becomes, is it a good idea? And so let me ask Mr. Goodlatte my final question. In this measure as offered, first by you and then whatever tweaking and whoever approved it, we are where we are now here today. Is there a process for enforcing the measure that is before us?
Oh, absolutely. There's a process.
And what is that process?
That process is both the public seeing whether or not members of Congress have complied with the constitutional requirement that you balance the budget. There are exceptions set forth in the constitutional amendment, and if those exceptions are not complied with, then we have elections every 2 years on which people can be held accountable for not complying with the Constitution. The issue of under what circumstances courts would take note of this is well discussed in this piece, which I have submitted for the record, and I think that would be rare. I don't think you're going to see the floodgate of litigation that you refer to, but I do think that it would not be proper to have a constitutional amendment where you took the jurisdiction of another branch of government completely away. So I think it meets the right balance between being far too specific about what remedies are or not having any remedies at all.
All right. Mr. Nettle, do you have a reaction to that?
Well, yes, most of the Constitution that we have is procedural. One of the problems with this amendment is that it's not procedural, it is substantive. And in order to enforce its substance, namely the budget must be balanced, substantive questions must be addressed. Is the budget balanced? Are the estimates correct? And in order to enforce it, then the courts, unless the courts aren't going to enforce it, in which case there's no point having a constitutional amendment.
Let me just say once again, Mr. Natter.
I'm sorry.
And just move the microphone a little forward. We can hear you.
If
really,
the courts,
really
if the,
well.
We normally don't have that problem, do we?
if the courts are not going to enforce it, there's no point having a constitutional amendment. You can appeal to the electorate and say they haven't balanced the budget. Oh, yes, we have, or it's just as well we haven't, or whatever, and you have a political debate. But if the courts are going to enforce it, which they are compelled to do as a constitutional amendment, they're going to have to make a judgment. Should we order an expenditure cut, and if so, which one? Should we order a tax increase, and if so, which one? You're going to put that in front of a court, and frankly, I don't know how a court makes those decisions. I agree with Mr. Goodlatte. Courts are not competent to make those decisions, but the only way to enforce this amendment is to force them to make those decisions. And that's very different from the way the Constitution is normally dealt with, because the Constitution normally doesn't deal with those kinds of substantive issues. It deals with procedural issues.
May I respond?
Of course, Mr. Goodlatte. It's my last question. It's still being answered, and Ms. Slaughter asked to be recognized, but Mr. Goodlatte is entitled, in my judgment, to a response. All right, I am asked another question.
I appreciate this bipartisan allowing me to respond. And let me just point out that 49 out of 50 states have constitutional amendments or other statutory requirements that they balance the budget. And I wouldn't say it has never wound up in court, but it does not wind up in court very often. Most states balance their budgets every year and do so without the interference of the judicial branch of their state government.
Can I comment?
Ms. Slaughter, Jerry, let us just move on. Ms. Slaughter.
Mr. Goodlatte, it's good to see you. As I was coming in, you were saying that this was a very fair process. I'd like to just bring up one point, if I may, and that is insufficient floor debate and no amendments. We've considered balanced budget amendments a number of times in the past, I think 5 or 6. Always been the practice, multiple alternatives that are debated and voted on, often as many as 6 substitutes. Always been lots of hours of debate, sometimes as many as 14, including amendments. The bipartisan precedent goes back decades and has been observed by both parties, but not on this bill. And I just was curious to why we're breaking with that practice here.
Well, I'm not the one who's writing the rules. In fact, this committee will determine what the rule will be. And I welcome as long a debate process as possible. But I also believe that this is an amendment that has been well vetted. It's been debated long and hard in the past, and I think the process of bringing it up under suspension with extended debate time is a fair process. It allows members to participate in that debate, but it is not a new concept. It's been debated and voted on in committee and elsewhere in the past, and I think that given the fact that this is a unique process where the Congress has actually legislated that the Congress will vote on a balanced budget amendment, doesn't make it a surprise that this is now coming up for a vote. I happen to think the process is a fair one, but I certainly understand the gentleman's comments.
The past debates probably wouldn't apply here, but the fact is that this has had no committee debate. What we're doing here today came up last week. There was, I understand, a vote in the Judiciary Committee on a balanced budget. That's not what you're using.
If you would yield, a version more objectionable to Democrats was very thoroughly debated, and Republican members heard that, listened, and came forward with an amendment that we think it has greater appeal to more members of the Democratic caucus.
Was that
and
voted
is more
on?
bipartisan. What?
Was it voted on?
This has not been voted on yet. I think we're going to do that at the end of the week.
It had no committee action.
Not in this Congress. A different version was voted on this
Do you
Congress.
have anything to say about that?
Well, I've already said what we debate. We had a hearing in general on the idea of a balanced budget amendment. When we asked the majority members, the majority witnesses, for comments on specifics, they refused to comment on specifics because they said they didn't know what the specifics were. They were only there to comment on in generalities. We did have a committee markup on a different balanced budget amendment, which I think Mr. Goodlatte is correct, is more objectionable from my personal point of view than this one. That passed. Yeah. But this amendment has never been considered or marked up or had any opportunity for vote or amendment or debate in the Judiciary Committee. And that is, and period.
Well, I thank Mr. Hastings and I yield back.
Thank you, Mr. Chairman. Thank you for being generous with the time, but I do deem it important not to ask a question, but to place in the record statements of some extraordinary practitioners regarding constitutional balance budget amendments. Judge Robert Bork opposed a balanced budget constitutional amendment, declaring, and I quote him, "The result would likely be hundreds, if not thousands, of lawsuits around the country, many of them on inconsistent theories and providing inconsistent results." The late Professor Archibald Cox predicted, and I quote, that there is a substantial chance, even a strong probability, that federal courts all over the country would be drawn into its interpretation and enforcement. Additionally, the former Solicitor General to President Reagan, Professor Charles R. Freed, has testified that the amendment would surely precipitate us into subtle and intricate legal questions, and the litigation that would ensue would be gruesome, intrusive, and not at all edifying. The former Attorney General to President George Bush, William Barr, opined that judicial power could be invoked to address serious and clear-cut violations. Finally, I'd like unanimous consent to enter into the record the statement of the American Constitution Society for Law and Policy over the signature of Neil Kemkoff, and I use his final paragraph to end. The threat a balanced budget would pose to our constitutional order is unavoidable. Congress, of course, remains free to enact a balanced budget amendment if it believes this is sound economic policy. It also remains fully equipped to institute effective controls to ensure restraint and balance in the budgeting process. Therefore, there is no sufficient reason to incur the dramatic risks that the balanced budget amendment would entail for our Constitution and our nation. I thank the Chair. Thank you very much, Mr. Chairman. All right.
Mr. Polis.
Thank you. Again, I think there's varying opinions on both sides of the aisle with regard to this. I don't support constitutional amendments lightly. I'm only a co-sponsor of two constitutional amendments. One is the Equal Rights Amendments, and our chair earlier referred to taking 7 years on average for an amendment to become part of our Constitution. This has been an effort since the 1970s. And is yet to be ratified. And I think society's moved a long way. I would love to see that included in our Constitution. The other amendment that I support as part of our Constitution is a balanced budget amendment. This isn't something that I supported when I first came to Congress, but after having been here 3 years, I've come to the conclusion that Congress is unlikely to do it on our own. But I question why we are bringing forth this particular version. Amending the Constitution is a very serious endeavor. I actually support two different versions of the balanced budget amendment. One, H.J. Res. 87 by Representative Carney, another H.J. Res. 81 by Representative Amash. Two key features I'd like to ask Mr. Goodlatte about, whether he supports these features. And Representative Carney's, it includes something that is part of nearly every that I know of state balanced budget amendment, which is the separation of the capital budget from the operational budget. And I was wondering whether that's a concept that he would support, having a capital budget, which doesn't necessarily need to be balanced. As anybody knows, you can bond and build, and then over time you have debt. States do that all the time. Is that a concept that you're open to as part of a balanced budget amendment, Mr. Goodlatte?
Well, if we were starting from scratch and we didn't have a $15 trillion debt, then certainly a bonding process where you would balance the budget and count the interest payments would be something, in my opinion, that would have merit. But where you're starting $15 trillion in the hole, I see it as a major impediment towards getting to a real balanced budget, and we would simply find a new way to avoid that reality. If we don't face some of the same limitations that the states face in that regard, and therefore, at this point in time, I would not support that particular provision.
Yeah, and I think what's critical with regard to having some element is how it affects our infrastructure. And I think everybody on both sides of the aisle, economists, et cetera, would agree that, if you're building something in the last 20 years, maybe you pay for it over 20 years, you don't expense that in year one. That's the way every private company and public company does their books.
If we had started out doing that, then that would be a good process to continue. But until our debt situation improves, I think it would be perilous to.
The other key element from H.J. Res. 81 that I think would make a balanced budget amendment better is a concept of a multi-year averaging approach. So again, economists generally dislike balanced budget amendments. However, economists also dislike unbalanced budgets. So, having to choose between the evils, if Congress can't balance a budget on our own, most economists would argue, perhaps you should do it where you don't ratchet it down quite as quickly in a down year, you don't ratchet up spending as quickly in an up year. I think that's a very compelling element, and I'd like to ask Mr. Goodlatte if that's an element that he'd be open to as part of a balanced budget amendment as well.
I think the idea of a multi-year averaging is a good concept. I believe that is better to be found in a budget act than in the Constitution itself, because you might find today that a 3-year average is a desirable average, and then you might find that it might be 4 years or 5 years or 2 years. This balanced budget amendment, because it allows for budget estimates, allows for the concept that's contained in Mr. Amash's constitutional amendment to be incorporated in a budget act that would be necessary under the enabling clause, and then the Congress, future Congresses would have the flexibility to determine whether a particular way of calculating how the budget is balanced, they would be able to do that.
I'm not sure I read this amendment the same way. I think this particular version requires that outlays don't exceed receipts in any fiscal year unless there's this supermajority waiver given. But I think that's every fiscal year it has to do that. There's no ratcheting.
But if you look at the provision in this dealing with how you calculate how a budget is balanced, the interpretation from the committee's attorneys is that would allow for flexibility on the part of the Congress in determining exactly how you reach that amount.
Mr. Nadler, did you agree or disagree on that?
I certainly disagree. The language, it's interesting to hear interpretations by anonymous attorneys, but the fact is the language is clear. Total outlays for any fiscal year shall not exceed total receipts for that fiscal year unless there's a 3/5 vote of the whole number of the House, period. So now a 3/5 vote of the House, of the whole number of the members of the House could say, well, let's average it over 3 years or 5 years or 100 years. But that's with a 3/5 vote, saying there's no provision here for anything such as Mr. Goodlatte was just saying. It's very clear. Total outlay shall not exceed total receipts for that fiscal year.
Would the gentleman yield on that point? If the gentleman would turn to Section 6, the very explicit provision that I'm referring to is contained there. Congress shall enforce and implement this article by appropriate legislation, which, and I quote, may rely on estimates of outlays and receipts.
Well, again, but going back to Section 1, again, I guess Mr. Nadler's our constitutional authority, but I mean, even as a layperson reading the Constitution, clearly Section 6 can't be done to contradict Section 1, which says pretty explicitly total outlays for any fiscal year shall not exceed total receipts for that fiscal year. So, I mean, I don't think that the implementation ability in Section 6 could be used to undermine Section 1. Mr. Nadler, is that?
Yeah, I would agree with that, and especially when you look at Section 2, or Section 3 rather, where it says the President shall submit a proposed budget in which total outlays do not exceed total receipts. Obviously, you're talking about estimates since you don't have the receipts in hand yet, and you haven't spent the money yet. Budgets are always done by estimates, how much our tax is going to raise this coming year, how much, et cetera. All this says is, when you have a provision that says Congress shall enforce and implement this article by appropriate legislation, fine. I'm not sure what power that adds that you don't have already, but maybe some, which may rely on estimates of outlays and receipts. That goes without saying. It certainly does not and cannot override a very specific command that says total outlays shall not exceed total receipts for any fiscal year.
So, and I think what we're finding here, is again, there's a lot of areas that need to be vetted. I believe, Mr. Goodlatte, that this Congress, the 112th Congress, there is a 2/3 majority to be found for a balanced budget amendment. However, I think that requires work, clearly work across the aisle. It might very well require compromise. But I think it could ultimately result in a better policy. We talked about maybe some of the advantages of including a capital budget, even something that addresses your concerns. Maybe after the federal debt is reduced a certain amount, then going forward there's a capital budget. I mean, you talk to anybody. I was in business before I was in Congress. I mean, not having a capital budget is just mind-boggling for anybody who's kind of looked at the balance sheet of a business, and yet the federal government continues to operate that way. Likewise, trying to hone in how you do the multi-year averaging in a way that conservative and liberal economists feel makes more sense for the economy. I mean, you save in good times and you have a surplus, and you perhaps don't ratchet it down quite as quickly when times are bad. I mean, a year is an arbitrary amount of time, 12 months, and what we really care about is long term. So, again, I take amending the Constitution very seriously. I think this Congress can do better. I think we can do it. I hope that our committee here on rules will grant an open rule that allows for the introduction of these ideas and others. There's been some discussion that Congress has debated balanced budget amendment before. Well, not this Congress, not me. I've been in Congress 3 years. This is the first time I've ever had this discussion, been part of this discussion, and a majority of this committee is in the same boat. Discussions by previous Congresses might have been engaged in by a minority of members, but certainly not by a majority of members. So I do hope that we can pass an open rule to consider elements of the Amash and Carney balanced budget amendments, perhaps to improve upon and build upon this, so we can feel good about inserting it in our governing document. I mean, a very serious discussion, and again, with the 112th Congress, I think we can get there, but I don't see this as a way of getting there. This is taking a particular version that apparently didn't even come through committee, just sort of appeared, has some already legal issues about whether, in fact, it allows multi-year averaging or not. We'll only have limited debate on the floor, no chances to amend it. And it doesn't seem to me the right way to go about amending our Constitution. So I hope to continue to work with my colleagues on both sides to see if there's a way that we can, most importantly, balance the budget. But failing that, require that we balance the budget, which would lead to us balancing the budget. And I yield back.
Thank you very much, Mr. Polis. As I prepare to recognize Mr. Woodall, I would just say to my colleagues in the minority that in 1974, when the Equal Rights Amendment passed, it passed under suspension of the rules. Mr. Goodall. Woodall.
Thank you, Mr. Chairman.
Goodlatte and Woodall.
And I appreciate my colleague from Colorado's comments. I know they're heartfelt. I am also a co-sponsor of the Amash amendment, and when you're dealing with an issue of this gravity, no one has been more passionate than Mr. Goodlatte in terms of trying to drive this issue forward. The chairman takes us back to 1974. I want to take us back to 1992, quoting from the New York Times in June of 1992. Today, the House of Representatives debated a constitutional amendment to require a balanced budget, to require a federal balanced budget, as its author declared that the change would give us a constitutional reason to find the courage to make the tough choices necessary to balance the budget. The House will vote on the amendment on Thursday. Representative Charlie Stenholm said the Texas Democrat who forced the issue to the floor despite the House leadership's opposition, House Democrat leadership at that time. And Stenholm steadfastly predicted passage. As I recall, it did not pass on that June day in 1992. Did pass in the summer of 1995. Mr. Goodlatte, how many times since 1995 have we had an opportunity to bring this amendment to the floor for a vote?
This amendment has not been to the floor since 1995, and you raise a very good point, Congressman Woodall, because that 1992 version brought by Congressman Stenholm was brought under a discharge petition, which is a process not too unlike the process that we are looking at here today, where we're bringing up under suspension of the rules. So I would argue that this is something that is very much driven by the members on both sides of the aisle who want to have a vote on a constitutional amendment, and that has brought us to this point here today. I would also point out that 2 additional hearings have been held on a constitutional amendment to balance the budget, and a number of prominent scholars testified in favor of a constitutional amendment at that time. So there are lots of different ways to look at it. I very much appreciate the work that the gentleman from Colorado has put into this issue, and we have, while trying to take into account the concerns of a great many people, have taken into account his concerns, particularly with regard to the averaging issue. We think that this does address that concern, but I'd be happy to have further discussion with him and other members. And I know there are lots of other members of the House who are busy discussing this process as well.
Well, and there are a lot of options out there. As Mr. Nadler said earlier, lots of different ideas about how to get this done. I know we've discussed that in conference. We've discussed that across the aisle as folks have been looking for co-sponsorship of their amendments. Mr. Nadler, of all those that are out there, which one is it? It's obviously not H.J. Res 2 that has your passion. Which version of the balanced budget amendment are you supporting?
Well, I wouldn't support any of them. I think a constitutional amendment for a balanced budget is a very bad idea for a number of reasons. I would say a couple of things. If you're going to have a balanced budget amendment, all the states that have, or at least all that I know of, do have a capital budget separated from your operating or expense budget. To require a capital budget, to require a balanced budget without separating your capital and your operating budgets, when you have a unified budget, as the federal government does, as no state does, as far as I know, no corporation does, is to say you should never borrow money for any purpose, except during wartime. or with an extraordinary vote. That makes no sense at all. If any family tried to operate that way, you want to buy a car, cash. You want to buy a house, cash, no mortgages, they'd have a much lower standard of living. Any corporation couldn't invest to expand or to operate. Now, Mr. Goodlatte says, well, he'd favor that if we were starting from scratch, we're starting with a $15 trillion deficit from the hole. He doesn't favor that. Well, we won't be in a $15 trillion hole forever, hopefully, but this amendment does not provide, after its period of time, to switch over to enable you to have a capital budget.
I share your optimism, Mr. Nadler, that we won't be in that position forever, though, as I told constituents back home during the last district work period just last week, I said, for Pete's sakes, here we are in the most conservative, budget-minded U.S. House of Representatives we've had in my lifetime. And the very best we could do was a Budget Committee budget. I sit on the Budget Committee. Very best we could do was a budget that continued to increase our debt for the next 27 years and then got around to thinking about paying down the first penny of the $15 trillion. And that budget was so panned by the left and by the White House that it never even got consideration in the Senate. So I share your optimism. I just wonder if you talk about the long wait for the ERA, for Pete's sakes, the long wait to begin the first payback of the first penny.
Well, we started.
$15 trillion on its way to $23 trillion by the end of the decade is a big job.
Well, if you want to, I don't want to get into a partisan debate, but if you want to know how to get out of a budget deficit, you have to know how you got into it. In 2001, Alan Greenspan testified against the then proposed Bush tax cuts because, in favor of them. He testified in favor of them because without those tax cuts, we were going to pay off the entire national debt by 2011 or 12. That was anticipated, and that would be a bad thing in his judgment because then the Federal Reserve Board wouldn't have monetary policy to manipulate. That would be bad. We would have paid off that. How did we change? We changed because we overshot the mark on tax cuts, because we had a couple of unfunded wars and various other things. We know how to get back there. The problem with the balanced budget amendment in generally, severalfold. Number one, almost any economist will tell you, when you're in good times, you should have surpluses. When you're in a recession or depression, you should prime the pump and have deficits. And what a balanced budget, and any time you go into a recession, by definition, you're going to get into, your tax receipts are going to go down, fewer people are working, people get unemployed in the recession, so fewer people are working, less income taxes, less sales taxes, et cetera, and unemployment insurance and other payouts get increased, so you can have a recession. At that point, to say you got to balance the budget, which means cut tax, increase taxes, or reduce expenditures, guarantees to change a recession into a depression. It's the last thing you want to do at that point. Secondly, we have heard testimony, Mr. Goodlatte and others have said, in justifying a balanced budget amendment, that Congress doesn't have the power to do it by itself. That is to balance the budget. We can't do it. We have to force ourselves.
I've heard testimony, we don't have the power, or we don't have the will.
Either way. We don't have the power of will. Call it what. No, we have the legal power. I didn't mean that. We have the legal power, but without a balanced budget amendment, without an amendment in the Constitution, it's not going to happen. We have that in the past, when we had the Graham-Rudin-Hollings bill, we had the PAYGO, Congress found ways around it. So we have to tie the hands of future Congresses. That's the rationale for this amendment. We have to tie the hands of future Congresses so that they won't find ways around whatever other expedients may be taken to guarantee a balanced budget. What that's really saying is we, in this year, should tie the hands of our descendants to our views of political economy. Maybe our descendants, as represented in Congress 20 or 30 years from now or 50 years from now, will disagree with the current majority. And maybe they will think a balanced budget is a bad idea, or for some reason it's justified not to have a balanced budget. We have to tie their hands.
I certainly
don't think it's right to tie the hands of the future.
I recognize that fear, though, given that Thomas Jefferson said over 2 centuries ago that if he could add but one amendment to the Constitution, it would be to eliminate the power of the federal government to borrow, because with that amendment, he would then trust that the power of the federal government would not grow unfettered. This is clearly not a new idea. It's not a happenstance of today. In fact, as I look back, and you all can remind me, I was not here in 93, 92, and not that student of history, but I believe between 1983 and 1995, either the House or Senate voted on a balanced budget amendment absolutely every single year. What is the facet of modern times is not the desire for a balanced budget amendment. It's been the last 15 years of inaction on a balanced budget amendment. That has been the new arrival here on Capitol Hill, and I'm glad to see us heading back to former times.
But there's a reason for that, and the reason for that is that starting in the mid-'90s, the early '90s, the Clinton administration, Congress, first Democratic, then Republican, took actions that resulted in a balanced budget and in surpluses. And so you showed in 1993 and again in 1997, in 1993, the Democrats under Clinton proposed a deficit reduction bill that passed by one vote and started the reduction of the deficits and then actually in surpluses. And in 1997, the Congress under the leadership of Gingrich and the President Clinton also had additional legislation, and we reversed it, and we went from very large deficits to very large surpluses, so large that they said in 2001 we were going to pay off the entire national debt in 2011 or 12. So it was clear that if you had the political will, you didn't need a balanced budget amendment to accomplish that task.
I voted in support of the agreement in August that gave us this opportunity to vote for a balanced budget amendment, and I'm just thrilled that it is available. But I recognize your concern that perhaps there are other alternatives that should be considered. Now, what I tell folks back home is that one of the really interesting facets of the agreement in August is it ensures that whatever we pass here absolutely gets consideration in the Democrat-controlled Senate. I mean, we're going to pass perhaps a Republican idea here. It's going to get consideration there. But it also ensures that whatever the Democrat idea is that passes there will also get consideration here. As you think about the ways that this amendment should be framed differently, what do you anticipate we're going to get back from the Senate? Because that's going to give us our second bite at that apple.
Well, I don't know that we're going to get back something that passes the Senate by two-thirds vote. I certainly hope not. I know if you're going to pass a balanced budget amendment, which I think is a very bad idea under any circumstances, you should certainly provide for separate our capital and operating budget. Otherwise, it's just absurd. No major corporation, no government can or should operate with a constitutional provision that says essentially you can never borrow money for any purpose without an extraordinary vote.
Well, with the information I see, 75% of American people supporting Congress taking this action. My question is not why are we doing this this week. My question is why haven't we done this long ago? And it would not be happening this week without the leadership of folks like Mr. Goodlatte. And I want to say again how much I appreciate your leadership on this issue. Thank you, Mr. Chairman.
Mr. Nugent.
Thank you, Mr. Chairman. Mr. Goodlatte, I signed as co-sponsor to both your bills, and also Amash's bill. I look back with the discussions and what could have been in 1997. We wouldn't be having discussions like this today. We wouldn't be sitting here with my kids owing more than they make in a salary in a year to pay down their share now of our debt, which they didn't have any part in creating. Had we only done the right thing in '97, and I agree with Mr. Polis, I would hope that Congress would have the ability to make the tough choices to do the right thing. But what I've seen, and this is Democrat and Republican alike, just haven't been up to the task to do it. And so I keep going back to only if we would have done, this Congress would, and the Senate would have done the right thing, the Congress did, but the U.S. House of Representatives did, but had the Senate done the right thing, at least the states would have had an opportunity to vote on it. Had it been ratified, we wouldn't be having this discussion about where we are today with a debt that is going to crush this country. And you're right. I mean, the Budget Committee, we're looking out, it's $15 trillion today, but the estimate is $20-some trillion in a few short years. I don't know how you escape the fact that if we just, once again, miss our golden opportunity to pass a balanced budget amendment, how we ever look our kids in the face and say, hey, listen, we've done everything we could. With that, I yield back the balance of my time.
Mr. Scott. Mr. Webster.
Well, Mr. Chairman, I would like to at least thank Mr. Goodlatte for bringing this forward. I think it's a great thing. I've been a part of more balanced budgets than any person in the United States Congress. And when I was in the legislature, we had a simple amendment that we followed. There was no implementing bill in the statutes. It only said every year you pass an appropriations bill, general act. Did it include capital and general appropriations? Yes, it did. It included capital too. Was it simple? Yes, it said that. The second thing it said was that the expenditures will not exceed revenue. That's it. Done. Simple. Just like this amendment does.
Will the gentleman yield for a moment?
Just a second. I don't talk a lot, so I don't interrupt anybody. So anyway, we did that, and I did it 32 times. And in my mind, a simple amendment gets the job done. The very day that this United States government's credit was reduced and the value of our credit was declined, that same day, Florida's was increased. Why? Because the legislature followed that little simple amendment, balanced the budget, and it worked. And so I've seen it work I don't even know what I've experienced. I've heard all these statements of this person said that, and that person speculated this. But this isn't speculation. It worked. Half of my time there was spent under Democrat control. Did they raise taxes to balance the budget? They did. Half of my time was spent with Republicans in control. They didn't. But either way, the job was done, and the state of Florida is much better off than this government here. And I think this simple amendment is an awesome opportunity to make things right.
Thank you very much, Mr. Webster. I wish my state of California would follow your Floridian model. Gentlemen, thank you both very much for being here. We appreciate it. That will conclude the hearing, and the chair will be in receipt of a motion.
Mr. Chairman, I move the committee report a rule that allows the Speaker to entertain motions to suspend the rules through the legislative day of Friday, November 18, 2011, related to House Joint Resolution 2, proposing a balanced budget amendment to the Constitution of the United States. Rule provides that debate on such a motion shall be extended to 5 hours. Finally, the rule provides that the chair may postpone further consideration of such motion to a time designated by the Speaker.
You've heard the motion of the gentleman from Dallas. Are there any amendments or discussion? Mrs. Slaughter.
Thank you, Mr. Chairman. First, may I ask unanimous consent to put the Statement of Administrative Policy on the record?
Without objection, a statement of administration policy will appear in the record.
Thank you very much, and I do have an amendment to the rule. I move to amend the rule to strike the words, quote, HJ Res 2, end quote, and insert, quote, HJ Res 1, end quote, as reported by the Committee on the Judiciary, to substitute what we're doing today with the one that passed the committee.
You've heard the motion of the gentlewoman. The vote occurs in the Slaughter amendment. Those in favor will say aye.
Aye.
Those opposed, no.
No.
Roll call, please.
Let's call the roll.
Mr. Sessions?
No.
Mr. Sessions, no. Mrs. Fox? No. Mrs. Fox, no. Mr. Bishop? Mr. Bishop, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Nugent? No. Mr. Nugent, no. Mr. Scott? No. Mr. Scott, no. Mr. Webster? Mr. Webster, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
And the clerk will report the total.
4 yeas, 8 nays.
Motion is not agreed.
Mr. Chairman?
Amendments? Mr. Polis,
Mr.
offer an amendment?
Mr. Chair, I move to amend the rule so that we would consider HJ Res 2 under an open rule instead of under suspension.
Heard the motion of the gentleman. Vote occurs in the Polis amendment. Those in favor will say aye.
Aye.
Opposed, no. No. Chair, the noes have it. The noes have
Roll
it.
call, Mr. Chair.
Call the roll.
Mr. Sessions?
No.
Mr. Sessions, no. Ms. Fox? No. Ms. Fox, no. Mr. Bishop? Mr. Bishop, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Nugent? Mr. Nugent, no. Mr. Scott? Mr. Scott, no. Mr. Webster? Mr. Webster, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Aye. Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
The motion is not agreed to. Are there further amendments? Not, the vote occurs. The motion of the gentleman from Dallas. Those in favor will say aye. Aye. Opposed, no.
No.
The ayes have it, the ayes have it, the motion is agreed to.
Roll call, please.
Clerk, call the roll.
Mr. Sessions.
Aye.
Mr. Sessions, aye. Mrs. Fox. Ms. Fox, aye. Mr. Bishop. Mr. Bishop, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Nugent. Mr. Nugent, aye. Mr. Scott. Mr. Scott, aye. Mr. Webster. Mr. Webster, aye. Ms. Slaughter.
No.
Mrs. Slaughter, no. Mr. McGovern. Mr. McGovern, no. Mr. Hastings. Mr. Hastings, no. Mr. Polis. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
And the clerk report the total.
8 yeas, 4 nays.
The motion is agreed to. This will be managed for the majority by Mr. Nugent.
And by Mr. Hastings for the minority.
Thank you all very much, and we'll see you tomorrow. Without objection, the committee.